state of Illinois appealing a judge's decision last month in federal court that the state's prohibition of individuals carrying concealed weapons on public transit is a violation of the Second Amendment. That appeal coming, at least the announcement of an appeal, on Friday. Good morning, it's Illinois in Focus Daily. I'm Greg Bishop, back after several weeks off, and glad to break down things happening for you here in the state of Illinois. So, of course, just the top line here, the defense of the state of Illinois, letting it be known that they are filing an appeal in this case. Schoenthal versus Raoul, and it deals with the prohibition of carrying firearms on public transit. Now, I'm going to take a look here at the Pacer account for this case, just to go all the way back to when this case came up, and in particular, when we saw this particular complaint filed. So let's go to the Pacer page where it looks like it was filed. Wow. Several years ago, back in 2022. So we're talking 2 years ago, the complaint was ultimately filed in the Northern District of Illinois. So a lot of back and forth with that case and the various filings. Then you get, throughout the year, more filings, the back and forth. They had an ultimate hearing on this, various status hearings. But last month, the order came out from the judge in this case, essentially denying the state's and the Cook County motion to dismiss the case and siding with the plaintiffs. So let's pull this up here. The memorandum, the order and opinion, as we see what the judge ultimately had to say in this. And pulling it up so that we can review this. But this is the order, and this was issued late last month, talking about the Illinois Firearms Concealed Carry Act, banning the carrying of firearms on public transit. And obviously a lot of back and forth and the precedent and the various arguments that were made. But ultimately the bottom line, let's get down to the conclusions here, where the judge lays it out as to what the outcome is of this case. And it says, as we get to the final remarks here, in the conclusive statements, keep going. Here we are. So, final couple of pages here. This action's been properly brought before this court, despite the disputes over venue and standing. The parties can't escape the court. The parties also can't escape that this case requires navigating the murky waters of Bruin. That's the New York State Rifle and Pistol Association v. Bruin case out of New York. Plaintiffs' proposed conduct, carrying concealed handguns on public transit for self-defense, falls within the presumptive ambit of the Second Amendment, shifting the burden to the defendants to show that the Firearm Concealed Carry Act's ban falls within the historical tradition of firearm regulation in this country. On the record before the court in this case, defendants have failed to meet their burden. As for injunctive relief, plaintiffs have made no argument regarding why they're entitled to injunctive relief. Because they've forfeited the argument, they haven't established their entitlement to an injunction. The claims against Rick Amato and Eric Reinhardt are dismissed without prejudice for lack of subject matter jurisdiction. Rick Amato and Eric Reinhardt are terminated from the case. The remaining state defendants' motion for summary judgment is denied. Kim Fox's motion for summary judgment is denied. Plaintiff's motion for summary judgments granted in part. The court grants declaratory relief against Kwame Raoul, Kimberly Fox, and Robert Berlin in their official capacities, that the Firearm Concealed Carry Act's ban on carrying concealed firearms in public transit, as defined in the statute, violates the Second Amendment, as applied to Benjamin Schoenthal, carrying a concealed firearm for self-defense on Metra and on Metra's real property to the extent necessary to ride Metra. Again, that's pretty specific relief given to Schoenthal. The court grants declaratory relief against Kwame Raoul and Kimberly Fox in their official capacities that the Firearm Concealed Carry Act's ban on carrying concealed firearms in public transportation, as defined in the statute, violates the Second Amendment as applied to several other individuals that are wanting to ride Metra, CTA. So that's Mark Robolinski, Joseph Vessel and Douglas Winston. Those, of course, are people who are getting relief on this, and that's all according to the federal district judge, Ian Johnson. So Johnson making that issue on August 30th. Governor J.B. Pritzker was asked about it shortly thereafter, a few days last month, and here's what he had to say in response to the federal judge, saying that the prohibition of carrying concealed firearms on public transit violates the Second Amendment.
Well, unfortunately, many of the conservative judges who've been appointed have misunderstood what it means to uphold public safety. And, we still believe in the Second Amendment. It's part of the Constitution that you have rights as a result of the Second Amendment, but there are limitations to that. I mean, just to give one example, the right to bear arms, it's not the right to a shoulder-fired missile, as one example. There are limitations on the kinds of weapons and the places that we need to. Would we allow people to carry an AR-15 into the White House? No. So it's clear that there are some misguided decisions that get made at the circuit court level, the federal court level, and I'm hoping that it'll be overturned along the way. If it has to go all the way to the Supreme Court, it'll be disappointing if they uphold this, but I'm hopeful that the law that was passed in Illinois a number of years ago that's frankly done a lot to keep people safe will be upheld.
So obviously he's saying that it's conservative federal judges that are making these decisions. I would imagine some people out there may point to Pritzker's involvement in the Illinois Supreme Court races and donating $1 million each to different Illinois Supreme Court justice candidates who ultimately did get elected and didn't recuse themselves in a couple of different cases. But regardless, interesting comments from the governor, and he was asked as well if he wants this to be appealed to the Seventh Circuit Court of Appeals.
That's not up to me. It's up to the Attorney General, although, we'll have to have some discussions about the best way forward in order to protect people as a result of that ruling.
And, of course, on Friday, they did indeed file that appeal, at least a notice of appeal. The Firearms Policy Coalition putting up that legal update saying that the public transportation carry ban filed ultimately an appeal in this. So late yesterday, they say, and this was on Saturday when they filed it on Friday. Late yesterday, the state filed a notice of appeal in our Schoenthal v. Raoul, Illinois public transportation carry ban lawsuit, asking for our victory to be reversed. Round 2 coming up. Stay tuned. So again, the notice of appeal says that defendants Kwame Raoul, Robert Berlin, Illinois officials sued in their official capacity hereby appeal to the United States Court of Appeals for the Seventh Circuit from the order and final judgment dated August 30th, 2024. By this appeal, defendants respectfully request the reversal of the district court's order granting partial summary judgment to plaintiffs. So we'll track this in the Seventh Circuit U.S. Court of Appeals and where it exactly goes. But obviously, it's not the only gun case. We've been tracking the ban on semi-automatic firearms and magazines over certain capacities. We had that case wrap up the bench trial on summary judgment, final action in the district court on Thursday in the Southern District of Illinois. Before the case even started, Governor Pritzker was asked about that case as well, and if he has concerns in particular with Judge Stephen McGlynn in the Southern District having previously issued a preliminary injunction in this case. Does that signal that he's going to put in a permanent injunction in this case?
Well, as you know, my administration doesn't act as the attorney for the state. The Attorney General does. And I have a great deal of faith in our really great Attorney General, Kwame Raoul, who has defended the state in every one of these cases. But I'd make the same remark about that case as I would about the Rockford case, which is, there are misguided judges who are making decisions that I think are inappropriate and do not hold dear public safety the way that we do. And so I'm hopeful that will get overturned at the decision will get made in mid-September the right way. But if it doesn't, that it'll get overturned by higher courts. Yes.
So again, Governor Pritzker saying that he believes that higher courts will ultimately reverse any outcome that goes against the state from the Southern District. But what about getting to the U.S. Supreme Courts in all of these cases? We'll be tracking it. All right, so be sure to like, subscribe, hit that notification bell for Illinois in Focus Daily as part of America's Talking Network right here on YouTube.